Alright, first case, McCulloch versus Maryland, 1819. McCulloch petitioner, Maryland respondent. This case came from U.S. Appeals Court, 4th Circuit, then to the Supreme Court. Chief Justice was John Marshall. The decision was unanimous. The majority opinion was given by Chief Justice John Marshall and ruled that Maryland's tax on the National Bank was unconstitutional. No, you can't do that. Was the Constitution questioned? Maryland imposed a tax on the National Bank. This violated the Necessary and Proper Clause, Article 1, Section 8, Clause 18. This was a win for Federalists. Federal is greater than state. Next,
Marbury versus Madison, 1803. Marbury is the petitioner, Madison is the respondent. Chief Justice John Marshall wrote the majority opinion. No dissenting opinion, majority agreement, unanimous decision. At this point in time, there is no path established for the case. Summary of case. Marbury was appointed to be Justice of the Peace at the end of John Adams' presidency. Commission was not yet delivered because Adams' presidency ended, and Secretary of State James Madison would not deliver Marbury's commission. This case established judicial review, which is legislative and executive actions are subject to review by the judiciary.
Gibbons v. Ogden, 1824. Gibbons is the respondent, Ogden is the petitioner. Chief Justice John Marshall wrote the majority opinion. William Johnson wrote a concurring opinion. The path of the case went from Court of Chancery to the Court of Errors to the Supreme Court. In this case, Ogden was seeking an injunction to stop Gibbons from operating steamboats on New York waters. In the Supreme Court, it was decided that Gibbons was allowed to use the waters because of a federal license was granted to him, which is superior to a state license. The ruling of this case upheld national supremacy. It was a win for the Federalists, and it violated the Federal Coasting Act of 1793.